You all ready to go on the record?
Yes, ma'am.
All right, the court is calling 2022 CR 11724, State of Texas versus Jordan Robbins. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Amy Owen for the defense.
All right. And the other two attorneys who are here?
Yes, Judge. Brandon Wong for Alexander Reed.
All right, so everybody, please do not whisper because the court reporter cannot hear. So,
Brandon Wong for Alexander Reed.
Yes, Your Honor. Rick Foster here for Dr. Javier Rodriguez.
all right. So before we get into the reason for the other two attorneys being present, I want to make sure that you have all the discovery from the state that the state has in its possession.
That the state has in its possession, I believe so, Your Honor. I do not know if that's what is in their possession is comprehensive of the order of the court of what was ordered to be turned over. I had not looked at that yet, since we do have it at final discovery, I believe. Setting, I think it's on the 24th.
On the
Or it's the
24th.
24th.
So this was set for the motion to quash today, and we already have a discovery setting set on the 24th.
Okay. All right. So let's go over the motion then. And I have a first amended motion.
Yes, Judge. Do you need a copy?
Oh, I have this. And did you file a motion as well, or is
I
this?
did not, Your Honor, found out about it yesterday, but we're subject to this motion because we're the doctor, one of the doctors that is being asked to produce records for Mr. Wong's client, Ms. Reed.
All right.
And Your Honor,
So defense.
Your Honor, so as the court's aware, we have argued, sort of argued this prior to the court. And we're not on a fishing expedition to for all of her medical records, but what we are interested in and looking for are medical records that occur between January 1st of 2022 up through January 31st of 2022.
All right. Do y'all want to write this down, what she's asking for?
I can get it.
Okay.
Let Mr. Wong know. So there's American Health Imaging on January 6th, 2022, January 18th with Dr. Nivra Beta, January 21st with Dr. Malhorta, and January 31st with North Central Baptist Hospital ER. And then we know that the outcry in this case is February 8th and 9th. And the reason we're asking for this, Your Honor, is that the mother of the complainant suffers from a frontal traumatic brain injury. We know that occurred in 2012. And those, because of, without revealing too much of our defensive strategy in this case, there's information contained within the case file of the civil discovery and within the court-ordered psychological evaluation by Dr. Richard Tice that gives us reason to believe that there could be exculpatory information contained within mother's medical records. Mother is outcry witness in this case. And we believe that what is contained within those records could be exculpatory. We're asking for the court to do it. We're not asking for them to be turned over. We're asking if the court would do an in-camera review of these records to see if there's anything relevant to this case in terms of symptoms and diagnoses of what happened within the 30 days of outcry. And that's what we're requesting.
All right. And state,
Yes.
are you planning on calling this witness as an outcry witness or calling this witness at all?
She would be the outcry witness, Your Honor. And we had a hearing previously on this, and our position as to why we did not feel that these records were necessary was because she is just the outcry witness. She's not, the allegations themselves come from the child. The child said these allegations multiple times. And it's just very attenuated from how there could be any relevancy. It's kind of well, there might be something in there. And we don't know that there is. And it's the state's view that it's outside our duties to provide, which is why they chose to subpoena independently.
Well, the court's question, this brain injury, did it occur before or after the alleged outcry?
Before.
About 10 years before.
All right.
Judge, obviously, they're asking for my client's protected HIPAA information. It's just clearly a fishing expedition. The subpoena is defective on its face. They actually didn't even follow the procedure. They didn't serve my client. They've never served my client with the actual subpoena for any of the records they're asking for. The subpoena is incorrect because it doesn't even list her name correctly, her birthday correctly. So again, no one can even provide the information they want because again, it's just defective on its face.
But obviously, you know,
Obviously, I know about it, but. and
'Cause
that's
you're
why we're
here.
But the reality is, Your Honor, as the state said, none of this information is remotely relevant. They're just trying to simply fish. My client, again, she's one of many outcry witnesses that have heard the child's statement. She's not the victim. She's not saying this happened to her.
but this is the person that the state is calling as an outcry.
I get it, Judge. But again, she's not the only one. And then they're still able to have my client on the stand, ask her whatever she wants, whatever they want. You know, that is, we all know that is how it works. And so they're able to get whatever information. They're trying to link something that happened 10 years ago and saying, well, now she got some sort of mental handicap where she is now convincing her child. And, you know, that's their strategy. It's not even a secret. They're trying to say that she has influenced her child to say that these allegations have occurred to her. It's a stretch to say the least, Your Honor. And so again, it's just harassment on the part of, you know, they're just making my client spend countless dollars and time fighting this thing. She has nothing to do with it. All she did, she made a report and that's it. She's out of it. And so again, for them to now seek all of her records, you know, now they're cutting it down. Originally it was her entire medical file, her entire medical records. And I understand they just want a couple visits here and there. But again, Your Honor, my client's still going to have to produce them. It's a hassle. There is nothing relevant that's going to come from this. And they're hearing it's possibly exculpatory. They don't know. There's nothing other than just their speculation. It's just pure speculation that they can come up here and say, you know, we just want to harass this lady to get these records just so we might be able to strengthen our defense. And again, as the prosecution has said, it's just not relevant.
Okay. And do you have an argument?
Your Honor, we just merely support the patient, Dr. Rodriguez's patient, Ms. Reed. It's her record. She doesn't want to produce them. We don't want to produce them. And it sounds like from the summary that was given by defense counsel, they're not even asking for Dr. Rodriguez's records at this point. Is that correct? Even
That's
though okay, so we have a subpoena, but you know, so we need protection from that subpoena. I can file a separate motion, or
Well,
we
I
can agree
mean,
on the record today that it's, or as the court determines, that
well,
subpoena is
just one
withdrawn.
second, because I'd like to
Oh, yes,
cut to
yes,
the
Your Honor.
point.
Okay.
So this attorney, his patient, or his
Doctor.
doctor,
Yes, Your Honor.
are there any records that you want from this doctor?
I don't believe so, Your Honor. However, since we don't have any, we don't know if it references, you know, any type of diagnosis or treatment that's referred back to that. But these specifically what I read are what we're requesting.
So here's the thing. Number one, he's saying that the subpoena is improper on its face because it doesn't have the correct name, the correct date of birth. I think we all know who it is and who we're here for. If you want to make another trip down to the courthouse and they can correct the name and the date of birth, they can do that. But I can tell you what my ruling is going to be. What my ruling is going to be is yes, I need to see it in camera inspection, and I will make a determination of whether it's relevant or not. If I deem that it's not relevant from the in-camera inspection, then that will be the end of it. But I can't make a determination on whether or not a record is relevant or not until I see it. So just listen to everybody's argument. I've listened to your argument, but I need to see what it is. So she is telling me she has narrowed it down to this specific thing. And my understanding from both sides, or let me make it clear to everybody, that's the specific thing. We're not going outside of that specific thing. So counsel, if there is something that you feel that the attorney who's here today, that there's something that they have, let them know specifically what it is. And then if you all will present it to the court, not to the state, not to the defense, just present it to me, I will review it. And then I will make a determination whether it's relevant or not. And my understanding from defense, they're no longer asking for the entirety of the record, which I would think the entirety of the record would not be relevant. But the specific parts she's asking for, I'll review them and make a decision on that. So First question. Are you going to want me to rule that on its face because it has the wrong date of birth, wrong name? And just
On its
say,
face, Judge, honestly, yes, Your Honor, they need to refile it.
all right, so
And then I'll
this
ask my client, once they've served a proper subpoena to provide said documents and then, because I understand what your ruling is, but
Mhm.
obviously I can't agree to release her records when it's just not been properly done.
all right, so when will you have your subpoena ready?
Today.
All right, so she's gonna have her subpoena ready today. So while she's getting her subpoena ready, if y'all can get those records ready for the time frame, if you give them the time frame, it's not, I read very quickly. It's not gonna take me long to do it and to review everything.
And Your Honor, I think the other issue would be that in order to for anybody to get the records, that the court would need to order Mr. Wong's client to sign a HIPAA release to the actual entities to be able to release the records to the court.
I'm not gonna order her to sign a HIPAA release,
Okay,
so.
so once we get the subpoena and then the court, we would direct the entity to send the records directly to the court.
Yes,
Okay,
and then if you all are able to get the records directly to make the process move quicker and bring them to me, and I will review them in camera. And as I said before, when I review things in camera, I really review them in camera. Defense doesn't see it, state doesn't see it, her client's not going to see it. I'll be the only person who's seeing it.
May I address?
Sure.
Your Honor, pursuant to HIPAA and the CFRs underneath that, we have, if it's a third-party subpoena, to be able to release the records, we need to be ordered to produce those records. And then there needs to be provisions that they're prohibited from using the records and disclosing them outside the litigation, and they're required to return the records upon the conclusion of the proceedings. And so
Here's my thing.
may I pass something up to the? court?
Sure. But you may pass it,
Yeah.
but I will tell you, I don't believe in crossing bridges until they're built.
Yes.
So the first thing we need to do is, if you all will confer on the date she's speaking about,
Yes.
and then she can have her new subpoena and you all just get the records prepared for the court. And if you all can have the records and bring them to me, because sometimes when things are mailed to the court, it goes to 6 different places. People don't read 187 4th floor with a suite number. So it goes to different places. And so nobody else will read it, just me. If y'all will bring it to me, and if you could put it in a sealed envelope that says judge only on it, nobody else will open it. The staff will not open it. It'll go specifically to me.
And
Okay.
can we go ahead and submit an agreed order on how those records are being tendered up to you, because you've directed us to do it?
Sure.
And
If you
put
all
it
with
with the documents?
yes.
Okay, you okay
Yes.
with that?
yeah, sounds
Okay.
great.
All right. And then she'll get the subpoena. But I will tell you, our next court date in this court for discovery matters are August 24th.
Yes.
So if you all can have all those records to me before August 24th, that would be great. If not, I can read it on August 24th, but I just like to have leisure reading before that date.
Okay,
All right, so August 24th. Does anybody need anything else?
No, Your Honor.
no, Your Honor.
All right, and if there's not any objections from the defense, if you all want to appear by Zoom, you're more than welcome to appear by Zoom, as long as I have the records to review in camera. Is there going to be any objection?
No, ma'am.
All right, so if you all would like to appear by Zoom, just let the court know. The court coordinator will give you the Zoom link.
That'll work. Thank you, Judge.
All right,
Good.
thank you.
Thank you, Your Honor. Maybe we see you.
Yes.
Thank you.
Hi, so, hello.
Hi.
So this attorney filed a motion for an examining trial. So that's going to be heard in Judge Carruthers Court. Do they have a date for it? They don't have a date for it set yet. But so he's filed that. In this court, we don't have pre-indictment cases. The only time pre-indictment cases come here is if someone requested it. So once your case gets indicted, that's when you'll start coming to court, unless your attorney wishes for you to come. And how you know your case is indicted, it'll have a CR number to it. So it'll be maybe 2023, then you'll see the letter CR. That means that it's been indicted. So have you been able to get in touch with him at all?
Yes, he said it was a federal court that he was gonna come here after.
All right, so if you want to wait for him here, you can wait for him here. But since he's already filed the motion for an examining trial, unless he wants something to happen with your case, nothing's going to happen to your case today. So you may want to text him and see if he wants you to stay here. Otherwise, you can let your bondsman know that you showed up today
Okay.
and that your case is really not on the docket today.
Okay. Do we need any documentation to take with us
No.
today or?
If there's an issue where the bondsman thinks he didn't show, you can have them call the court.
Okay,
All right, but we don't have a date to give you.
okay. Thank you so much.
All right, you're welcome.
Thank you.
All right, have a good day. Hey, enjoy the rest of the day with your son now. All right, and Mr. Ross, you're over here and your client's in the middle.
That's right. You have to tell me everything.
That's okay. It keeps my mind sharp. All right, who's the prosecutor on Alberto Soto? It's an aggravated robbery. Where are we on discovery?
I think I have it all. I've got to review. There's some videos that I've got to review.
Okay. And has an offer been tendered?
It has.
All right, so I'm going to give you a plea deadline, Mr. Soto. And I'm going to set your plea deadline date in September. On that day, you need to let the court know whether or not you're accepting the state's offer. Do you understand? All right, how old are you?
63.
All right, I'm going to set you for September 11th. And on that day, you need to let the court know whether or not you're accepting the state's plea. Of course, if you decide to enter a plea bargain agreement and your counsel wants it placed on the docket sooner than that, then he can do that.
I'll come see you. I've got to look at all the videos. 5 years ago. They won't give it to you. I'll come see you after look at the videos. Okay? I'll come see you. We'll talk. Okay?
Mr. Ross, have a great day.
Thank you, ma'am. I will. You always cheer me up. You always got positive answers.
Hey, you know what? We have to live this life, whether we want to live it or not, and
Of course,
there's no harm in being joyful.
of course, you're putting on a show for your mom too. right?
Oh, no, my mom, let me just tell you, my mom always tells us that one, things could always be worse.
Absolutely.
And two, what have you got to be, sad about? Why shouldn't you be happy? She said, you're currently alive.
All you gotta do is walk around the streets and see all the handicapped people, the sick people, the
Well-
hurt people. That's all you gotta do.
My mom also says that the only time you have a problem is if you have a problem that money can't solve. And when you think about it, if you have a problem that money can solve, it's not really a problem because it can be solved. But if there's a health issue and money can't solve that, that's a problem. So anytime it's a problem that money can't solve, that's a real problem.
Quick story. I got a son rides motorcycles.
Mhm.
About 4 weeks ago, he hit a deer. Destroyed his bike, got put in a ditch, ended up with 5 broken ribs, something wrong with his back. Went to hospital. That was kind of, well, he's already bought a new motorcycle. He's out trying to ride it. He did the same thing 10 years ago. In other words, I'm gonna tell you now, I had a grandchild one time. She was little. She hurt herself. She started crying. I said, sweetheart, no blood. You can wiggle your fingers. Nothing broken. Sometimes you just have to get up and get on with stuff. A few weeks later, I was in Houston playing with her. I played with her. We bumped heads. And I started, oh, gee, Dad. Sometimes you just have to get up and keep going.
Yeah.
Right back. But that's the way it is. You just gotta live life and you go forward.
That's it.
Thank you. I see.
All right, have a good one. Who's here on Jordan Robbins?
I am, Your Honor.
Mr. Ross, Mr. Ross.
You may sign it.
All right. Hello, everyone.
Good morning, Your Honor.
I recognize all the attorneys. Hello. Oh, there's somebody new here. Who's new here?
Yes, Your Honor. Rick Foster. I represent one of the physicians whose documents been requested.
Okay,
Dr.
so,
Rodriguez.
all right, and who is the prosecutor on this case?
I am your honor.
Okay.
It was not my motion. The hospital.
Oh, no. Okay. So,
What day is that?
all right, everyone, please whisper. So, other than this hearing that we're about to have with regards to the subpoena is there any other discovery that the state has in their possession that you need?
Your Honor, seconds before they were called up, I was advising that there was some kind of records that came in on Friday. I think it might be related to this subpoena. I haven't had a chance to review it. I was gonna run upstairs and grab it.
All right, so let's see if that's it, because then you will have already turned it over to the state, if that's what it is.
We didn't turn over anything, Judge. We're asking to quash the subpoena.
Well, no, she's saying
Well, let me
that
go
she's
check.
received
It might be
something.
something separate.
On the form we got on e-discovery, it just said notice of additional discovery, but that it was checkmarked like medical records. I think it was handwritten in, and I didn't have a chance yet to talk with them about what that is.
So
We were also awaiting the remainder of the pediatrician records of the child, so it could be that too.
All right, so let's see what it is in case it is this, because sometimes people accidentally do things. And if they've accidentally already turned it over, then that's a problem not on my plate. So she's gonna go check that, then I'll call you all back up as soon as she sees what records they are.
Yes, ma'am.
All right, court is calling 2022 CR 11792, State of Texas versus Nelda Rios. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Albert Chidas from Israel's.
are you Nelda Rios?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nelda Rios who was placed on deferred adjudication in 2022 CR 11792 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram on April 19, 2023 for a period of 2 years? Is that you?
I do gotta say, I don't remember. I do have a head injury, but
All right, she doesn't remember that she was placed on deferred adjudication. Do you know when she had this head injury? Was it before or after she was
it
placed on
was-
probation?
It was before, Judge, and she did remember earlier when we were talking. It's something that I was talking with the state and with probation about. She does have some deficits. She goes to Center for Healthcare Services for treatment.
All right, so do y'all think she's competent?
She has been, this is the first, she says she doesn't remember being on probation. And we had actually talked about trying to help her because she was homeless. There's some issues that came up. She's on SSI for her head injury, but she lost her ID. And when that happened, she got evicted from housing. So we could work something out with Haven for Hope, get them to help her get her ID temporarily.
So are you all looking to withdraw the motion and alternate main conditions?
Judge, we thought that it would be better to come and have the motion heard, but again, that's up to you.
I think it would be best probably to withdraw and alternate main conditions.
Your Honor, we were looking to maybe getting some evaluations done while she was in custody.
Ah. So what evaluations are we looking at?
The TAP
Mental
and
health.
mental health evaluation.
My only concern is I understand y'all want to do that in custody, but she's telling me she doesn't remember signing conditions or being on probation. She doesn't have a place to stay?
She was living under a bridge when she was arrested.
All right. So here's my question for you. One or two things can happen. You can remain in custody. While in custody, you will be evaluated. We can reset the motion to revoke, and you can be evaluated for the mental health caseload. Would you like to do that?
I already know that I'm not capable of, that I cannot. Like, you have to tell me all over again, because I didn't understand it.
All right, let's do this. Why don't we see whether or not the mental health court will accept her? I know they only do pretrial diversions, but if nobody's going to object to it, I'm willing to do a motion for new trial. And we can start all over, because I see I'm not the person who took this plea. So if you would check with mental health court to see if they'll accept her, because that may be the better placement for her. Because I think she's going to need one-on-one care. So if you'll check with mental health court and let them know, and you'll have to let them know that she's currently on deferred adjudication, but I'm willing, if nobody objects, to hear a motion for new trial, grant the motion for new trial, because the key is to get her the mental health treatment, and this is a possession less than a gram case.
Yes, Judge.
Okay, so is everybody on board with that?
Yes, Judge.
Yes, Judge.
All right, so what I'm going to do is I'm going to reset you for 2 weeks. There may not be anything completed in 2 weeks' time because mental health court will have to interview you, but I just don't want to lose track of you in the system. Okay? Do you have any questions?
No.
All right, do you have any family?
I don't. I have that. Sometimes I don't even have money to buy me a meal.
Okay,
I haven't been able to have a bank account with Bank of America, but because I don't have an ID, because when I got arrested, I was in my apartment. And it's a long story. But I had gotten a better criminal trespassing in my apartment, and that's why I got arrested for this case. I'm sorry for it.
oh no,
We came to court and went through all this process, but being out, I don't even have money to buy me something to eat or pay for motel room because of everything I've lost. And I got arrested at the motel. And I know that I have had issues with mental health since I was 10 years old.
okay. All right, so we're going to give you a 2-week reset. And that's just so I won't lose track of you. So now we have a plan. We're going to try to get you in the mental health court and probation. Could you see about the mental health case evaluation while she's in custody, just in case that doesn't work out?
Yes, sure.
All right, is there anything else?
No, Your Honor.
All right, Ms. Ferguson, I need a 2-week reset on Nelda Rios, please. You're welcome. All right, so we're going to put it down for August 29th.
Thank you, Judge.
All right, Deputy, before you take her back, Ms. Ferguson, can you give her a reset form so she'll remember?
Yes, ma'am.
Good morning. All right, Mr. Reed, you were late for court. Why?
Yes, ma'am. I apologize. It won't happen again. I had difficulty this morning trying to get my bearing on where it was at. Okay.
I'm sorry, what?
I had difficulty this morning getting my bearing on where the courtroom was at.
Okay, all right, so now you know where it
Yes,
is.
ma'am.
All right,
That'll never happen again.
all right, so where are we on this case?
It's a first setting, Judge. I've spoken to my client. There seem to be some parole issues that we need to get to the bottom of before we can negotiate any kind of offer.
Okay,
So we just need time to figure that stuff out.
all right. And so he has a parole hearing.
No, Judge, he's on parole. They haven't issued a violation. They haven't issued a blue warrant, anything like that. So we want to kind of tiptoe to make sure that whatever deal we take isn't a moot point.
Okay. All right, Ms. Ferguson, on this case, give me a 45-day reset. You can put it down as discovery.
I can do September 28th.
All right, September 28th, just get the reset form, then you're excused. If for any reason he has a parole hearing or something on that date, just let the court know.
I appreciate it, Judge. Thank you.
All right, you're welcome. All right, so if you. So the last time we were here, there was some discovery on mental health issues.
So, Your Honor,
And then it was supposed to be a referral to mental health court.
that, I apologize, Your Honor, I didn't know about that update.
I go to the VA for mental health, and I have been since 2008. While I was active duty and
Okay.
after as well.
Yes, Your Honor, and we're trying to obtain that information so that we can present it for the state for possible mitigation.
All right. So is this going to be a referral to mental health court or no? Because the last time we were here, there's supposed to be a referral to mental health court. And this happened in July. So has that been done?
Not, no, Your Honor. I need, if I can reapproach Your Honor and get better information, but I don't.
All right, so I can tell y'all that was supposed to be done, the referral to mental health court. Now, if he's a veteran, if you all want to see if Veteran Treatments Court is willing to accept him, you can also see that. And if that's the case, then we'll have someone from Veterans Treatment Court come down now.
Okay, Your Honor. If I can just step back.
Sure. Okay,
Thank you.
no problem.